Welcome to the Analyst. Today we'll be taking up 5 newspaper articles from the Hindu and the Indian Express and discussing them. The first article that we'll be taking up is related to juvenile justice. As the Juvenile Justice Board cancelled the bail of a 17-year-old who crashed a luxury car after a public outcry. The second article is related to Andhra Telangana stalemate, as Hyderabad will cease to be the common capital of the states of Andhra Pradesh and Telangana on June 2. The third article is related to BIMSTEC, as the first charter of BIMSTEC has come into force on May 20th. The fourth article is related to voter turnout data concerns, as the Supreme Court is hearing a petition filed by an NGO, Association for Democratic Reforms, which has challenged the authenticity of the Election Commission of India's voter turnout data. The fifth article is related to RBI Surplus Transfer, as RBI has approved the highest surplus transfer of more than 2 lakh crore rupees to the central government. Additionally, we'll also be taking up 4 Prelims snippets as well. Now, the first article is related to juvenile justice. The context behind it is that the Juvenile Justice Board cancelled the bail of a 17-year-old who was accused of driving a luxury car which had knocked down and killed 2 persons in Pune. So, we will be discussing juvenile justice in India, whether children of the age 16 to 18 years can be tried as adults, what is the role of Juvenile Justice Board, what are the concerns related to the Juvenile Justice Act. This is important in the topic governance in GS2. Now, how can children be tried as adults in India? It can be done under the Juvenile Justice Act of 2015. If a child of the age of 16 to 18 years commits an offence which is categorized as a heinous offence under this act, then he or she can be tried as an adult in India. Now, the act itself categorizes the offences under 3 parts: the petty offences, serious offences and heinous offences. The heinous offences are those offences for which the prescribed punishment is more than 7 years. For this, there are about 46 offences including rape, murder, drugs, etc. Under this act, section 15 provides that if a heinous offence has been allegedly committed by a child who is more than 16 years of age, then the Juvenile Justice Board will conduct a preliminary assessment. It will be the duty of the Juvenile Justice Board to conduct a preliminary assessment to determine whether the mental and physical capacity of the child is enough to commit such an offence, whether the child has such a cognitive ability to understand the consequences of such an offence for which he has been alleged that he has committed it, and what are the circumstances under which the child committed the offence allegedly. Considering these, a preliminary assessment will be done by the Juvenile Justice Board to determine whether that child should be tried as an adult, although he is not. He is less than 18 years but more than 16 years of age. Now, once the Juvenile Justice Board determines that he or she should be tried like an adult, then it will pass an order under section 18 subclause 3 of the Juvenile Justice Act 2015. The Juvenile Justice Board will pass an order to transfer the case to the Children's Court. The Children's Court is equivalent to a Sessions Court which will be conducting the trial in that case. Now, the sole objective of this preliminary assessment which will be conducted by the Juvenile Justice Board will be to determine whether that child should be tried as an adult or not beyond that. Now, what apart from this is the responsibility of the Juvenile Justice Board? It conducts the preliminary assessment. This report, it will be sharing the order with the child's family and the counsel for the child. It will also be having a member who will be an expert in child psychology or child psychiatry. At least one member of the Juvenile Justice Board will have expertise in this. If it does not have, then it will be taking assistance of an expert who is an expert in child psychology or child psychiatry from the outside. Plus, it will be providing free legal aid. It will be providing legal aid counsel to the child or the accused also. Apart from this, it will take into consideration a social investigation report. This social investigation report is usually prepared by a child welfare officer or any social worker after discussing with the child's family and investigating the circumstances as well. And this report is taken into consideration while preparing the preliminary assessment by the Juvenile Justice Board. Now, this is the procedure of determining whether the child of more than 16 years of age can be tried as an adult in case he or she has committed a heinous offense. Now, there are concerns related to this. Whether this will be a good idea or not, there are philosophical concerns. For example, there is little evidence that it will prevent juvenile crime in future. What if it turns juveniles into even more hardened criminals, because once they are tried as adults, they won't be sent to child homes, they will rather be sent to jails, and they will be coming into contact with more hardened criminals, and the chances for their reform will be low. Plus, the criteria that the heinous offense is any offense which will be having a punishment of more than 7 years of imprisonment, it is also debatable, because there are about 46 offenses. When we think about heinous offenses, we think about offenses like rape, murder, etc. But there are offenses under Narcotic Drugs and Psychotropic Substances Act also, which are having punishment of more than 7 years. And if a child gets into wrong company and he indulges in such activities, then also he can be said to have committed a heinous offense. And there are the guarantees of equality. The Constitution guarantees the right to equality in the form of Article 14 and no discrimination based on age under Article 15 as well. Now, if some children who are aged more than 16 and less than 18 are tried like children, whereas others are treated and tried in the courts like adults, then it will be violating their right to equality as per some schools. There are international norms also which may be violated if children are tried as adults. For example, the United Nations Convention on the Child Rights, India has also signed and ratified it. Although there are some other countries also who have ratified the United Nations Convention on Child Rights, for example Germany, and they also try children as adults in certain cases. There is the case of USA also, which tries children like adults, but it has not ratified the United Nations Convention. Plus, when it introduced the policy of treating children like adults in the case of certain offenses, then the juvenile crime rate in USA was very high. Almost 8,000 crimes out of a lakh were committed by juveniles in 1996 in USA when it introduced that policy. Whereas such is not the case in India. The rate of crimes which are committed by the juveniles is not as much in India to introduce such a thing. Then the policy is also allegedly guided by emotion rather than evidence in India. For example, this provision of treating children of more than 16 years of age like adults and trying them like adults in the courts, this was introduced after the 2012 gang rape case, which again led to a public outcry, and therefore some scholars say that this provision was introduced because of public emotion rather than evidence that it will reduce the juvenile crime in future. These are the concerns. Let's look at some other provisions of the Juvenile Justice Act of 2015 as well. One, it provides for the protection of children also. It provides for adoption provisions. That earlier, the adoption orders were passed by the civil courts, that is, the adoption agency will be applying for the adoption order to a civil court, and the civil court will be passing or issuing such an adoption order. Now it is passed by the district magistrates. The DMs, they are issuing all such orders related to adoption, and the adoption agency, which is called CORA, that is also accorded the statutory status under this act. It is talking about the appeals also. The appeals against the adoption orders which are passed by the district magistrates, they are filed in front of the divisional commissioner. It can be filed within 30 days and they have to be decided within 4 weeks of filing the appeal. The designated court earlier, for the offenses which were less than 7 years of punishment, they were tried by a judicial magistrate. Whereas if the offences were having a punishment prescription of more than 7 years, then they were tried by the children's court. But now the case is that all the offences are tried by the children's courts only. There is the provision of child welfare committees also. These child welfare committees are constituted by the states. The states are mandated to constitute one or more child welfare committees in each district, and the act also provides for the criteria for the appointment of the members to the child welfare committees. For example, that the member should be at least involved in health, education or welfare of children for at least 7 years, or the member should be practicing professionally with a degree in child psychology, psychiatry, law or social work. So this Act of Juvenile Justice 2015, it also takes into account provisions for the protection of children apart from prescribing the provision for trying children like adults if they commit heinous offences and they are of more than 16 years of age. Now the next article is related to the stalemate between the states of Andhra Pradesh and Telangana. The context behind it is that Hyderabad will cease to be the common capital of Telangana and Andhra Pradesh on June 2, and even after more than 8 years of bifurcation of the state, the division of assets and liabilities between the two states, that is still pending. So this is important in the paper GS2 under the topic governance. Before talking about the current stalemate, let's go into the background and discuss a little regarding the formation and the genesis of Telangana as well. Initially, Telangana was part of the Hyderabad state, and the Nizam of Hyderabad was not willing to merge with India after India gained independence in 1947. So the Indian government had to conduct the Operation Polo, and subsequently the state of Hyderabad was merged in India. Now after that there was the demand for the creation of a separate state which consists of all the population which speaks Telugu, and for this the spearhead was Potti Sriramulu. And after this there was the creation of Andhra in 1953. But in 1953, the Andhra Pradesh state did not have the regions of Telangana, the Hyderabad region at that time. But after this, the State Reorganization Commission, which consisted of K.M. Panikar, Hridanath Kunjuru, etc., they recommended that the regions which are also Telugu speaking, they should also be included in the state of Andhra Pradesh. And in 1956, the erstwhile state of Andhra Pradesh came into being, that is, which consisted of the regions of Telangana, Rayalaseema and coastal Andhra. But after this, the Telangana movement started. Because the region of Telangana, it was under the rule of Nizams, it was a feudal region, and it did not have as much economic development or even education levels as compared to the remaining Andhra Pradesh state, which was under the erstwhile Madras Presidency. Therefore, the people of the region of Telangana were afraid that the jobs will be going to the people belonging to the coastal Andhra region, and therefore they always wanted a separate state for the Telangana region. On the other hand, simultaneously there was the Seemandhra movement also. Seemandhra is referred to the region which consists jointly of the Rayalaseema as well as coastal Andhra. These two regions jointly, they are called as Seemandhra. They contended that the region does not have enough industrial avenues or enough government undertakings, etc. Therefore, the region of Telangana should also be a part of Andhra Pradesh, and it should be a single state consisting of the entire population of the people who are speaking Telugu. Therefore, finally, the Parliament enacted the Andhra Pradesh Reorganization Act 2014, despite the Assembly of the erstwhile Andhra Pradesh state passing a resolution that the state should not be bifurcated. Now, Article 3 under the Indian Constitution provides that an opinion should be taken from the Legislative Assembly of a state which is sought to be bifurcated. But this won't be binding upon the central government. And although the Andhra Pradesh Legislative Assembly passed a resolution against the bifurcation, but the central government went ahead and enacted the Act of the Reorganization of Andhra Pradesh in 2014. And therefore, the Telangana state came into being. Now it consists of 10 districts from the northwestern region of the state of erstwhile Andhra Pradesh. Now, what are the issues between the Andhra Pradesh and Telangana coming back to the present day? One is the issue of division of assets and liabilities. When a state is bifurcated into two, then the assets and liabilities of the institutions, the undertakings of the state, they have to be divided among the two successor states. But it has not been done since past more than 8 years also, because there are issues regarding the interpretation of the provisions of the Andhra Pradesh Reorganization Act of 2014. There are 245 institutions with a total fixed asset value of more than 1.4 lakh crore rupees, and 91 institutions are under Schedule 9 and 142 institutions are under Schedule 10 of this Reorganization Act of 2014. Another 12 institutions have not been mentioned, and now those 12 institutions have also become a bone of contention. The Andhra Pradesh government meanwhile has also approached the Supreme Court seeking a quick resolution of these issues and the division of assets and liabilities. Now, what is the stand of Andhra Pradesh government in this regard? The Andhra Pradesh government seeks the implementation of the Sheila Bhide Committee recommendations. This committee recommended that out of the 91 institutions which are mentioned under Schedule 9 of the Reorganization Act, 89 should be bifurcated. Their assets and liabilities should be divided between the states of Andhra Pradesh and Telangana. Whereas the Andhra Pradesh government also accuses Telangana government of selectively implementing and accepting the recommendations of Sheila Bhide Committee, and it has led to further issues and a delay in the division of assets and liabilities. Now, what is the stand of Telangana? The Telangana government says that the recommendations of this committee go against the interests of Telangana because the division of assets that are not part of the headquarter assets, that has also been included in the committee, and it claims that the section 53 of the Reorganization Act clearly defines the division of the headquarter assets and the assets and liabilities of any undertaking, any institution which is exclusively located in a geographical area or a part of it is located in a geographical area and its operations are confined to a local area, then the assets and liabilities for that portion will go to that respective state where it is located. And the assets which are located outside the erstwhile United State, they can be divided based upon the population. For example, it has assets in the form of Andhra Bhavan in Delhi. So it is shared by both the governments and they can be divided on the basis of population and apportioned between the states of Andhra Pradesh and Telangana. For this, there has been a clarification which has been issued by the Home Ministry as well. It issued a memorandum whereby it clarified that subsection 1 of section 53 of the Reorganization Act clearly says that the assets and liabilities, they have to be apportioned on the basis of location only. That is, the assets and liabilities of the institution which are located in a particular geographical area, they can be apportioned on the basis of the population. Now, the third article is related to BIMSTEC. The context behind it is that the first charter of BIMSTEC came into force on 20th of May. So we will be discussing the background of BIMSTEC, the challenges that it faces. This is important in GS2 under the topics bilateral, regional and global groupings and agreements involving India and affecting India's interests. Now first let's discuss the background of BIMSTEC. BIMSTEC is an economic bloc. It stands for the Bay of Bengal Initiative for Multi-Sectoral Technical and Economic Cooperation. It was founded originally in 1997 through the Bangkok Declaration. Initially, it had only 4 member states, that is, it consisted of Bangladesh, India, Sri Lanka and Thailand. Later on, 3 more countries joined, that is Nepal, Bhutan and Myanmar. So now it consists of 7 member countries. Now, what is the importance of BIMSTEC? It accounts for about 22% of the world's population. Therefore, it accounts for a significant demography of the world and it contributes to about $2.7 trillion of combined GDP. Therefore, it has economic value as well. 1/4 of the world's traded goods cross the Bay of Bengal every year. So, a significant amount of trade passes through this region. Initially, there were 6 focus areas of this bloc, that is trade, technology, energy, transport, tourism and fisheries. Now, the focus areas have increased to 14. The economic bloc works on the basis of sector-driven cooperation. That is, each member country can identify the sectors where it wants to take lead and prioritize those sectors. For example, India prioritizes and takes leads in the sectors like environment and disaster management, counter-terrorism initiatives, transport and cooperation, etc. The permanent secretariat of BIMSTEC is in Dhaka, Bangladesh. The aim of this economic bloc is actually to counter globalization. It aims to counter the onslaught of globalization by accelerating regional growth through mutual cooperation, utilizing the resources of this region. The first summit of this bloc was held in Thailand, and Sri Lanka was the current chair when the adoption of the first charter of BIMSTEC took place. Now, what is the significance of BIMSTEC for the member countries? Let's look at them one by one. Bangladesh looks at BIMSTEC as a platform where it can project itself as not just a small country, but rather a player which can have a say at the regional and global groupings as well. Sri Lanka looks at BIMSTEC because it wants to utilize the platform to project itself as a hub for the connectivity to the South Asian region and the Bay of Bengal region, because it has deep sea water ports, it is strategically located near the sea lanes of communication, etc. Nepal and Bhutan want to counter their disadvantage of being landlocked. Therefore, the connectivity plans of BIMSTEC will be helping the countries of Nepal and Bhutan. Myanmar and Thailand look at BIMSTEC because through this platform they can cooperate with India. They can get access to the consumer markets of India, and they can also use it to counter China, to balance the strategic moves of Beijing by engaging with India also. And India looks at BIMSTEC as an alternative to SAARC. Plus, it is an important way to look forward and to implement its neighborhood first policy. But there are certain challenges for BIMSTEC. For example, regarding trade. As a percentage of the total trade, foreign trade that India carries out with the world, in the 1950s, the trade with the BIMSTEC region was in double digits. Whereas in 2020, the trade that India carries out with the BIMSTEC region as a percentage of the total trade that it carries out with any foreign country is only about 4% as of 2020. There is a sluggish pace of implementation of the plans which are formulated in BIMSTEC, for example, the connectivity plans, etc. Plus, there is the discord between the member countries. For example, between Bangladesh and Myanmar, after the Rohingya crisis, more than 1 million Rohingyas entered into Bangladesh, and it has become a bone of contention between Bangladesh and Myanmar. Similarly, after the coup of 2021, in Myanmar, again refugees entered from Myanmar into Thailand. Again there is a dispute. Plus, there is the battle for dominance between India and China, because China has been financing the BIMSTEC region, the South Asian region, and building infrastructure at breakneck speed through its initiatives like Belt and Road Initiative, and India has to match it through other platforms like BIMSTEC. Now, what is the charter for the BIMSTEC that it has adopted? The first charter of BIMSTEC. It was adopted during its 5th summit in March 2022, but it came into force on May 20th, 2024. Through this charter, the economic bloc has acquired the status of a legal personality. What does this legal personality mean? It means that it will be like a person or entity who has rights and duties in law. That is, it will be having rights also and duties also, and it can now enter into structured diplomatic dialogue with other groupings and countries. It can have formal dialogues and negotiations with other groupings as well, because now it has an official charter. Plus, it will be having a legal and institutional framework now for a meaningful cooperation and deeper integration of the Bay of Bengal region. Now, how can we move ahead for BIMSTEC? There are a few suggestions also. One, we can suggest the creation of a zone of peace. We can call it the Bay of Bengal Zone of Peace. It will be to counter the increasing militarization of the region, to decrease the presence of military in the region, to increase trade and connectivity in the region. We can establish this zone like a zone of peace. We can improve trade through establishing free trade agreement. We can put in place a BIMSTEC free trade agreement so that India also gets access to the Southeast Asian market of the countries of Myanmar and Thailand. And the connectivity plan. Implementation is the key issue here. If it is implemented at a fast pace, it will lead to the growth of BIMSTEC. Now, the next article is related to voter turnout data concerns. The context behind it is that the Supreme Court is hearing a petition filed by an NGO, Association for Democratic Reforms. The NGO has questioned the authenticity of the voter turnout data, which is published by the Election Commission. This is important in GS2 under the topic Salient Features of the Representation of People Act. Now, what is the petition of the NGO ADR which is alleging discrepancies in the voter turnout data? First, let's look at this. The NGO has alleged that there is over 5% difference from the initial turnout figures which were given by the Election Commission of India and the final figures which were published by the Election Commission of India on its website. There is a discrepancy. Therefore, the opposition has also raised concerns that there can be manipulation of this voter turnout data, because there is an unusual increase of the voter turnout which is mentioned in the final release by the Election Commission of India as compared to the initial figures which were released. And also the Rampur Lok Sabha constituency returning officer has not furnished the copies of Form 17C. These copies were asked by an independent candidate and they were not furnished. This is an independent petition which was also being heard by the Supreme Court. Now, first let's look at this Form 17C and what is its significance. Under the Conduct of Election Rules 1961, the Election Commission of India prepares two forms, Form 17A and Form 17C. They contain the details of the voters and the votes which are polled for the candidates. Form 17A has the details of every voter who came to the polling booth and cast his vote. And Form 17C contains the details, the accounts of all the votes recorded at the polling booth. And to ensure transparency, the presiding officer is mandated to furnish a copy of the entries which are made in the Form 17C to all the candidates or their agents who are deployed at the polling booth. These copies are subsequently used, these copies of Form 17C, they are utilized by the candidates and their agents to cross-verify with the voter turnout data, to check whether they are authentic, whether there is any manipulation or not. And if there are any anomalies, then they can file an election petition also in any high court, because they can claim that there is some malpractice and the data between the Form 17C and the voter turnout data which is released, it is not matching. It is to ensure transparency essentially. So to ensure this transparency, what is the ADR petition seeking from the Supreme Court? The NGO has sought that the Supreme Court should issue directions to the Election Commission of India. Directions that it should upload the polling station wise data within 48 hours. So that there are little chances of any discrepancy or manipulation. Plus, there are contentions that not every party is able to deploy its candidates or its agents at every polling booth. There are some small parties also which, owing to financial constraints, they are not able to deploy its agents at every polling booth. For that, the Election Commission of India should itself upload the voter turnout data within 48 hours of the end of polling. What is the response of Election Commission of India to this claim of disparities? It has said that there is no legal mandate. There is no legal mandate which asks the Election Commission of India to share Form 17C voter turnout data to every person apart from the candidates. It can be shared with the candidates. Apart from that, no one else can claim it. There is no legal mandate. The Election Commission of India claims that it is a voluntary and non-statutory initiative that it has put in place. It discloses the voter turnout data through its app, through its website, through various press releases on its own to infuse transparency in the process. It is a voluntary one and it is an initiative for transparency only. And it says that the NGO, the Association for Democratic Reforms, has ignored that the figures in the non-statutory voter turnout app, they were secondary and provisional data. And this data is updated in the final voter turnout data, and it is alleging that there is a mala fide campaign which is being carried out to malign the Election Commission of India to affect its image. Now, what are the takes of some experts on this? They say that usually the Election Commission of India discloses the absolute numbers in the voter turnouts, that is how many votes were polled, but this time they have disclosed the voter turnout in terms of percentages, not the absolute numbers. So there are contentions that it may not be correct. Generally, it is released within 24 hours, but this time they are delaying it, and there is an increase in the voter turnout in the final figures which have been released by the Election Commission of India. Now this is unusually high. Usually there is an increase, but this time it is unusually high, and they suggest that why don't you upload a scanned copy of the Form 17C on the Election Commission of India website itself, so that everything comes in the open domain and there is transparency and there is no chances of opacity. Now, the next article is related to the surplus transfer by the Reserve Bank of India. The context behind it is that the RBI has approved a highest ever surplus transfer or a dividend transfer of more than 2 lakh crore rupees to the central government for the accounting year 2023-2024. For this, we will be discussing the revised economic capital framework and understanding the impact of this surplus transfer also. This is important in GS3 under the topic Indian economy and issues related to planning, mobilization of resources, growth, development and employment. Now, before coming on to the surplus transfer by RBI, let's also understand the economic capital framework. This economic capital framework is a methodology for the level of risk provisions and profit distribution. That is, when the RBI earns something, out of these profits, it has to reserve some part for the bad debts, for depreciation of assets, for the contribution to the staff, etc. And out of that remaining, it has to balance some part of it to the central government, the profit distribution part, and remaining it keeps for the risk provisions. Under section 47 of the RBI Act 1934, the central bank is required to pay the balance of its profits after the risk provisions to the central government. The old economic capital framework was developed in 2014-15 and it was operationalized in 2015-16. But after that, Dr. Bimal Jalan committee was formed to review this old economic capital framework and to propose a suitable surplus distribution policy, because at that time RBI had a lot of surplus which it retained rather than transferring to the central government, and therefore the revised economic capital framework came into picture after the Bimal Jalan committee recommendations. This economic capital framework is reviewed after every 5 years, and earlier they used to target only the total economic capital. That is, the total economic capital, which consisted of capital, reserves, risk provisions and revaluation balances, etc. That was considered to determine how much surplus should be transferred by the RBI to the central government. But the revised economic capital framework targets, they also include the realized equity. The realized equity is that component of the total economic capital of the bank which consists of capitals, reserves and risk provisions. So this total economic capital, as per the revised economic capital framework, if it is between 20% to 25% of the RBI's balance sheet, then the remaining should be transferred to the central government. And the RBI also keeps a contingent risk buffer, usually in the range of 5.5% to 6.5% as per the revised economic capital framework. So now the RBI is maintaining a CRB of 6.5% because India has had a robust economic growth in the past few months. Therefore, that has been increased, the risk buffer has been increased from 6% to 6.5%, and the remaining has been transferred to the central government, because if the realized equity it is above the required levels, then the entire net income of RBI will be transferred to the government. Whereas if the realized equity is less than the target levels, then some portion of it is retained to achieve the required levels, and then the entire net income remaining after that is transferred to the central government. Now, let's also look at the reasons behind the highest ever surplus transfer that has been done by the RBI to the central government. One reason is there is the rise in the revenues of RBI. The revenues that it collects from the variable repo rate auctions. These are auctions to help banks when they are facing a liquidity crunch. When there are tight monetary conditions, then the RBI gives them money, and for that it earns interest rate. Then there are revaluation gains on the forex reserves, because whenever rupee is depreciating against the dollar, then there is more surplus which RBI can generate, and the interest rates on the domestic and foreign securities that is higher. Therefore, it leads to more income for RBI, and there are higher gross sales of foreign exchange, which again leads to more surplus, and there is surplus income on the investments. The investments that RBI has, there is surplus income on that, and the valuation changes on the dollar holdings, and RBI also gets fees from printing currency and rupees depreciation against the dollar. All these factors combined, they lead to more generation of revenues and more generation of surplus for the RBI, and therefore when it is more than the target levels, it is transferred to the central government. What will be the impact of it? One, the additional fiscal revenue of about 0.4% of GDP will be there at the hands of the government, and it is likely to help in easing the fiscal deficit, because the government has fiscal deficit targets to reduce it, and it will be able to ease it and reduce it by about 0.2% of the GDP. Now we'll be discussing 4 prelim snippets also related to Baltic Sea, rangelands, Model Code of Conduct, and the Production Linked Incentive Scheme. Baltic Sea is in news, and let's look at the countries which are bordering the Baltic Sea first. It borders the Baltic countries Estonia, Latvia, Lithuania, Poland, Germany, Denmark, and Sweden and Finland and Russia. Now, it is a part of the North Atlantic Ocean, and it separates the Scandinavian peninsula from the rest of the continental Europe. It connects to the Atlantic Ocean also through the Danish Straits. It is the largest expanse of brackish water in the world, although the salinity of the water in the Baltic Sea is low, because there are rivers also which are draining into it, and there is local water coming into it. It is a shallow sea. The average depth of this sea is about 55 meters only, and there are 3 major gulfs in this region. The Gulf of Bothnia, it is near the northern region, and the Gulf of Finland, which can be seen here, and the Gulf of Riga. There are some islands also in this sea. There are about 20 islands and archipelagos as well in this sea. The next article is related to rangelands, because a recent report by the United Nations Convention to Combat Desertification, the report on Global Land Outlook thematic report on rangelands and pastoralists, has published that the rangelands are experiencing a silent demise. They are disappearing. What are rangelands? Rangelands are natural grasslands. They are natural grasslands used by livestock and wild animals to graze, to forage, etc. And they consist of vegetation which can be tall grass prairies, steppes. Steppes are short grass prairies only, desert shrublands, shrub woodlands, savannas and tundras, etc. They can be called as wild open spaces also, because 40 to 50% of the Earth's land area consists of rangelands only, but they are degrading. What are the reasons behind their degradation? They are being converted to croplands and the land use is changing. Because of the population growth, because of the urbanization, the pastures are being converted, they are disappearing, converted into cropland, and the demand for food, fiber and fuel, it has been ever increasing. It has led to excessive grazing also, which leads to degradation of rangelands. What is the significance of rangelands? One, it is important for livestock forage, wildlife habitat, water, mineral resources, wood products, wildland recreation, and it has a lot of World Heritage sites also. It is shaping customs, cultures, value systems and identities of pastoralists also, and about 2 billion people, mostly farmers, ranchers, pastoralists, etc. They are dependent upon rangelands. The next article is related to the Model Code of Conduct. Now, we'll be talking about the main provisions of the Model Code of Conduct. Regarding the general conduct, it says that the differences should not be aggravated by the political parties' leaders in their speeches, and they should not create mutual hatred, they should not cause tension among different groups, linguistic, caste, regional groups, etc. They should not indulge in corrupt practices and offences which are defined under the election law. For example, they should not indulge in bribing of voters, intimidation of voters, impersonation of another candidates or voters, and they should not converse within 100 meters of polling stations, etc. And there should not be any criticism of private life. If it has no bearing or impact on the public life of a person, then the private life should not be unduly commented upon. Regarding meetings, if the political party is going to conduct a meeting for conversing for election purposes, etc., it should inform the local authorities, police station in advance, so that they can make the necessary arrangements for it to ensure law and order and peace in the region. For the uses of loudspeakers and other such facilities, etc., for the purposes of meetings, the political parties are supposed to obtain permission or license from the local authorities. If the political parties are going to conduct any procession, then the date and time of the starting, the conclusion of the procession, the route of the procession, etc. should be shared with the local authorities so that they can make the necessary arrangements to ensure law and order. On the polling day also, there are guidelines which have to be followed by the political party candidates and their agents. For example, they should not distribute liquor, etc. Then regarding the party in power, there are specific guidelines. For example, they should not utilize official machinery for canvassing, for seeking of votes, etc. And the advertising, if it is done by the party in power, it should not be done at the cost of the public exchequer. It should be done out of the party funds also. There should not be any misutilization of public resources. Regarding the election manifestos also, there are guidelines. For example, the ideals and principles which are enshrined in the constitution, they have to be adhered to while preparing the election manifestos by the candidates and parties. And if they are making promises that are likely to exert undue influence on the voters, then such promises also amount to the violation of the Model Code of Conduct. The next article is related to the production linked incentive scheme. This is a scheme for large scale industries to promote manufacturing in India. It was introduced to promote electronics manufacturing in particular in India, and it proposes financial incentives to the industries. That is, if they are producing more, manufacturing more, there are incentives given to boost domestic manufacturing and to attract larger investments in the electronic value chain industry, to promote the semiconductor chips making industry also in India, and mobile phones and specified electronic components, etc. Now, what does it say? This scheme was notified in 2020 and its second round was again launched in 2021 also. The eligibility is determined on the basis of the incremental investment and production which is done by the industries. And what is the quantum of incentive? How do the large scale manufacturers or industries gain under this scheme? There is an incentive of 4% to 6% on the incremental sales over the base year. That is, if their sales are increasing, they are getting more incentive for a period of 5 years. And there is an incentive of 3 to 5% on the incremental sales under the second round also. And the target segments, they are mostly related to electronics. For example, mobile phones, if their invoice value is more than 15,000 rupees, that is high-end smartphones, etc. also. And there are some specified electronic components as well. There is an empowered committee to oversee the implementation of this scheme, which consists of the CEO Niti Aayog, the Secretary Economic Affairs, the Secretary Expenditure, the Secretary Ministry of Information and Technology, Secretary Revenue, and the Secretary of DPIIT, Department of Promotion of Industry and Internal Trade, and the Director General of Foreign Trade. Thank you.